Hello, folks. Very good to see you all. My name is Killian Garvey. I'm a planning barrister at King's Chambers, and I'm here today to talk to you about the government's new draft National Planning Policy Framework. Before I continue, can I just get someone giving me a thumbs up or something to give me an indication that you can actually hear me? Oh, there we go. Lots of thumbs up. Thank you very much. I should say thank you very much for joining me. It's always a real surprise to me that so many of you want to hear about anything I'm going to say, but thank you so much for doing so. So there's a lot to talk about with this draft NPPF. I'm going to be talking about it for about the next hour, and I'm going to do my best to be taking questions throughout. Do please ask questions. I'll do my best to work through them. The consultation version of the draft NPPF is out now for commentary until the 10th of March 2026. For context, the first iteration of the NPPF came out in March 2012. Since that date, we've had 6 different iterations of the framework, and each different iteration brought different degrees of change, but the document each time looked familiar each time in terms of form. But now we have a new proposed draft NPPF, which at first blush, certainly my reaction, I don't know what others thought if they've opened it, but I thought this is a radical redesign of national policy. But the more I've dug into it, the more I've thought, well, there's a lot of changes in form that are superficially different. In substance, there are changes. Some are not as radical as it appears at first, but we're going to go through some of the big key points. There's too much to go through in 1 hour, but I'm going to focus on some of the big key points. So I'm going to jump in straight away with the presumption in favour of sustainable development. And I'm going to share my screen, so hopefully you can see. Here's the draft version, and we're going straight in at page 22, which is we've got achieving sustainable development, and we're going to deal with this presumption. So the first thing to note is at the beginning of each chapter, you'll see that there's a text in a box here, which is the objective. We're told what the text is because we see this at the beginning of each chapter, and we're told what this is. I should say, apologies, I'm going to be jumping all over the NPPF. So apologies for anyone who gets vertigo trying to follow me. But what we're told what these objectives are. Short objectives boxes are included in the box text at the start of chapters for context only and should not be applied as either plan-making or decision-making policy. So we get the box, and then after that, you'll immediately notice is you've got plan-making policies and you've got national decision-making policies. So this is a new theme that runs throughout this new NPPF, which is a division, a clear divide between the policies intended to work for plan-making and policies intended to work for decision-making. And we're also told that there's not meant to be a crossover between these different policies. And we see that in paragraph 8 on page 3. Here we go, yeah. The thematic chapters contain both plan-making policies and national decision-making policies, so the approach to particular topics can be seen in the round. However, the plan-making policies should not be used when making decisions on development proposals. So it's quite clear when you're in the development management context, you sort of cast out and ignore the whole section on plan-making and just focus on those development management policies. We then have a list of paragraphs, and we then have what these are, these development decision-making policies. So again, I'm going to dig into this in the context of the sustainable development. But what we've got, and you'll immediately see, anyone who's familiar with the NPPF, which I'm going to imagine is most of you, is that you've got paragraphs that go throughout. That's gone away with. Now we've got specific policies, more like a development plan. And you'll be saying policy S3, 1A or 1B, or in which sometimes, S4, 2A, Roman numeral 2. So that's just the new language that we'll get used to. It's a change in form rather than substance, but it just means any policy that you've ever written, any sort of planning statement or officer report or otherwise that you've been writing, we're going to have to get used to a very different language. But these national development management policies, what are they? So what are these management policies? The first thing to note is they're non-statutory, which is upset some. That we're told development plans shouldn't duplicate them. So we see that at page 10 under PM6, that when we're preparing plans, you shouldn't duplicate, substantively restate, or modify in the context of national decision-making policies unless directed by other policies in the framework. So ultimately, for a lot of development management, the future should be that one looks at the NPPF for a lot of development management decision in terms of issues like landscape, heritage, or otherwise, and one wouldn't need to duplicate those policies within your statutory development plan. We're told that these national development management policies, decision-making policies, are they should be read as a whole, and we're told that on page 3. National decision-making policies should also be read as a whole, including relevant footnotes and annexes. And critically, we're told about the weight to be afforded to policies that conflict with them. So if I go all the way to page 98, we're told that development plan policies which are in any way inconsistent with the national decision-making policy in the framework should be given very limited weight, except where they've been examined and adopted against this framework, which essentially means that when, assuming this version survives the consultation and we don't see something substantially different to this, if this was the national policy tomorrow, any development plan which is inconsistent with this NPPF that policy should be afforded very limited weight. Effectively, these national decision-making policies almost usurp the role of the development plan. That's in that sense, and become the new tools to decide where development should and shouldn't go. Now, obviously, in the legal context, the starting point is make decisions in accordance with the statutory development plan. But clearly, decision makers are being told. But if there is a conflict between these national policies in the NPPF, so just guidance, versus policies in the statutory development plan, you effectively should, where there's an inconsistency, you give primacy to the policies in the NPPF and you give very limited weight to the policies in the development plan. Okay, so that's what they are. I'm going to focus a lot of this talk on the development management side of this NPPF rather than the plan making, and for reasons I'll come on to, because it's the reality that we're going to be having to live with sooner. But going back to this presumption in favour of sustainable development, so that hopefully gives you a flavour of how this document reads, and that idea of plan making, national decision making policies is the structure all throughout this framework. But if we look at how it's dealt with in the context of the presumption in favour of sustainable development, we're told if you're within a settlement, you apply policy S4, which we'll come on to, S4. If you're outside a settlement, you apply policy S5, which again, we'll come on to. And then in all locations, so irrespective of whether you're in or out of a settlement, if you accord with an update development plan and also the decision-making policy in the framework, you should be approved without delay. Okay, so that obviously begs the question, are you or are you not inside a settlement? We have to jump to page 111 for the definition section of this, which tells us that a settlement includes cities, towns, villages, and other predominantly built-up areas, including land which is allocated or has permission for development, which will form part of the built-up area once the development is complete. This includes areas defined as a settlement in the development plan, whether using defined settlement boundaries or equivalent terms or criteria for identifying settlement extents. Settlements do not include hamlets and scattered groups of houses located outside predominantly built-up areas unless specifically defined as a settlement in the development plan. There'll be plenty of occasions where that's a really straightforward question as to whether you're in a settlement, typically settlement boundaries. But there will be countless occasions where it will be open for debate. Are you or are you not inside a settlement? And that has a bearing on whether you're applying S4 or S5. But I'll revisit that question as to whether that's actually going to be hugely important. Because if you're in a settlement, so therefore you're applying policy S4, then you get a tilt in favour of development. Development should be approved unless the benefits doing so would substantially outweighed by any adverse effects. So the language used to be significantly and demonstrably outweighed. The adverse effects would significantly demonstrably outweigh the benefits. Now we have substantially outweighed. Some will say, I'm sure, that substantially outweighed is a greater tilt towards development. There was a High Court case called Ward in the Secretary of State where the court said that the word significant and the word substantially don't necessarily mean a different scale of weight. They can actually mean the same word, and it's a matter of context. And the court was talking about that in the context of the NPPF and policies on Greenbelt. But I imagine most people would think, well, means a greater tilt. I imagine that's what most people are going to say. This means that if it was significantly demonstrably outweighed, now it's substantially outweighed. It's even a higher burden. And that test of being substantially outweighed, you'll see that actually applies if you are within a settlement. And if we look at S5, it's similarly the same if you're outside a settlement, subject to certain criteria. That's one of the main differences here. So if you're in a settlement, sort of automatically get that tilt in favour of development, and it would only be refused where there are specific circumstances, for example, where there's an allocation or safeguarding of land, and there's no reasonable prospect of that coming forward, or it's existing open space. But the idea is, within a settlement, strong tilt towards development unless certain circumstances apply, which include failure to comply with one of the national decision-making policies, which state development proposals should be refused in specific circumstances. Some of you might be familiar with the restrictions in the current versions of the NPPF, which is, it's your flood risk policies, it's your heritage policies, it's your greenbelt policies. And that normally would often thought to disengage the tilted balance. And that has been with us through various iterations of the framework. In the 2012 version of the framework, we had the language was unless there's specific policies which indicate development should be restricted. We then got a new version of the NPPF which talked about a clear reason for refusal. The current iteration of the framework talks about a strong reason for refusal. It's notionally gone away with, but you can still disengage that tilted balance where there's a specific policy which says development should be refused. And we'll come on to some of those policies, but there aren't actually that many. I'm just going to pause there and see how we're getting on questions. Paul Skelton says, how literally should we take inconsistent in any way? I think, Paul, that's entirely on its, as it says. I mean, ultimately, what you're asking about, I'll share my screen again, Paul. What you're asking about is that where you've got a tension between an existing development plan policy and a policy in we're talking about the implementation section. So where you're talking about an inconsistency between new NPPF and existing development plan policy. I mean, inconsistent in any way. I think it's always going to be fact specific, but ultimately, normally what you'd be thinking about is if there's a restriction in a development plan that is not found within this NPPF, normally you'd be thinking, well, then therefore it's more onerous. And in that context, if it's more onerous to meet the development plan policy than it is the NPPF, then you effectively give that restriction very limited weight. So it's going to detooth some development decision-making policies. Thanks for the question. Paul Jenkins. Paul Jenkins says it seems odd that we've got a non-statutory NPPF which would trump a statutory development plan. Yeah, I can certainly see, Paul, that's why you'd think that, because the legal test doesn't change in terms of the decision maker has to make determinations, and I know you all know this, in accordance with the statutory development plan, unless material considerations indicate otherwise. The NPPF is simply a material consideration, but it's a material consideration which is telling decision makers that if there's context, if there is a dispute between your statutory development plan and your NPPF, NPPF is telling you give very limited weight. And we actually see at the very beginning of this NPPF, it tells us it's a material consideration of critical importance in both contexts, both plan making and decision making. So I see legally why that seems odd, but it works. Certainly it makes sense to me. And I'm not really here to give a commentary as to whether these are good or bad things. I'm really just trying to help people understand what it's saying. But I can certainly see why that on first blush seems like an odd position. And I think Christian's making the same point. Yes, in terms of NPPF trumping development plan policies, you're talking about Christian raising the point about Section 38.5, that if you've got a tension between two development plan policies, the most recent policy prevails. That this is not saying, in a roundabout way, Christian, it's making the same point, actually, which is if you've got a tension between NPPF and your existing development plan policy, one doesn't necessarily, you don't discount the development plan policy. It's still the statutory development plan, but there's a mandate to the decision maker. You just give very limited weight to what's in those development plan policies, which in effect means ignore that, focus on the NPPF. That's essentially how I take from that. Okay, then I'm going to move back on to, so Gareth asks, on S4, there's a defined village settlement in the Greenbelt, you get the tilt in favour development. Under the current NPPF, you wouldn't get the tilted balance, but now you sort of. How do you think more in terms of Greenbelt development? I'll come back to that. I'll come back to the Gareth, because we're going to talk on Greenbelt and we're going to talk about how Greenbelt policies comes. But thanks for the question. Right, I'm going to move to policy S5, folks, which is the policy talking about development outside settlement boundaries for the purposes of decision making. So we've obviously talked about if you're in, you get the tilt in favour. If you're outside settlement boundaries, you get the tilt in favour where you meet any specific ones of A to J. I've seen some people ask, do you need to meet them all? No, you need to meet one of them. Each one is a separate exception that would allow for development outside a settlement. And we see the redevelopment of pre-developed land, which to my mind gives a real policy teeth to support a pre-developed land, which I've always felt like there's been lots of rhetoric about previously developed land, but there's not actually been that much policy support for such sites. But this gives that policy support. You get, if you previously developed land outside of a settlement boundary, you get the tilted balance in favour of you. Limited infilling outside. Railway stations. So this is a new emphasis that government are bringing in, that if you've got proximity to railway stations, effectively there's a new policy imperative to supporting those sorts of schemes. Allocated sites, and then here we go. Development which would address an evidenced unmet need, including but not limited to where the local planning authority don't have a 5-year housing land supply or have failed the most recent housing delivery test in terms of below 75%, and they'd be well related to the existing settlement, and that settlement has facilities and infrastructure essentially to support that, which is the very sort of classic position that's been advanced through various iterations of the framework, which is if the council don't have a 5-year housing land supply, you get the benefit of the tilted balance. Now, I said earlier about the debate about whether you're in or outside of a settlement. In reality, if you're promoting a housing site and it's not clear whether you're in or outside of the settlement, you've got an arguable stab either way. It might be considered. It doesn't actually make that much of a difference whether you're going through policy S4 or S5. I think in reality, you'd argue we comply with one or the other, because if you're within the settlement, then you get the tilted balance in favour of you. If you're outside the settlement, if they don't have a supply, you still get the tilted balance. You'd need to be able to argue that you're well related to the existing settlement. But I suppose if it's arguable that you're in the settlement, that one would imagine that's a given. So it might not actually make that much of a difference with this settlement argument in those circumstances. We then also get, I talked earlier about this clear reason to refusal, strong reason to refuse, and that is notionally gone, but we still have it, that the circumstances in which the adverse effects would be the benefits would be substantially outweighed is where there's a failure to comply with one of the national decision-making policies, which state development proposals should be refused in specific circumstances. So I'll give you an example of that. Plucking out of the air, so page 56. Yeah, development proposals that do not make efficient use of land in accordance with this policy should be refused. So let's say you've got a site, you're outside of settlement, but the council don't have a 5-year housing land supply. In those circumstances, the tilted balance would apply. So it would need to be that the adverse effects substantially outweigh the benefits. But we're told that the adverse effects would likely substantially outweigh the benefits where you're contrary to a national decision-making policy that says you should be refused. So if you don't achieve efficient use of land, that is one of those instances. So bringing it back to S5. Forgive me, I'm still getting myself familiarized with jumping up and down, jumping back and forth within it. In a circumstance in which the benefits of approving development are likely to be substantially outweighed, not mandatory, but are likely to be substantially outweighed, is where you fail to comply. So in that instance, you don't have a 5-year housing land supply. So let's assume you satisfy J. So you're well related to the existing settlement, and the settlement's got the scale for that quantum of development. But in the context of that tilted balance, if you've not got efficient use of land, national decision-making policy says you be refused, and that's likely a situation where the tilted balance should point against development. Let me pause there and see how people are reacting to that. Jonathan, it says, draft NPPF seems to be more restrictive when it comes to small-scale residential development adjacent to villages. It appears that the site must now be within the settlement. Is that your interpretation? No, I don't think so, because I think if you're adjacent to a settlement, then I think you could say, well, we're well related to an existing settlement, because we're told footnote 29 is talking about where there might be an allocation to come that sort of brings your scheme forward. But I think if you're adjacent to the settlement, that means you're well related to it. So I don't think that you're more restrictive in that circumstance, provided the council don't have a 5-year housing land supply, and you can run this argument. You've also got, as I said, other avenues, limited infill, for example. Rebecca, what regard should be given to local green space in settlements given the changes to the green belt and grey belt? They are still given a huge amount of significance, and we can see that in S4, that in applying S4, circumstances with benefits of approving development are likely to be substantially outweighed, i.e. circumstances where the tilted balance is likely to point against development, where you'd have an unacceptable impact on local green space. So even within settlements, they're still given that policy support. I'm going to take a few more questions and I'll jump back. John says, I wonder whether there'll be a debate about the definition of settlement, whether one goes to the NPPF or the local plan definition. Would this be a conflict? I think, John, it will depend on the site. Ultimately, there will definitely be circumstances where there is that debate. But if you're a developer and you are arguing that in the council don't have a 5-year supply, you might think to yourself, it's a sort of academic debate, because if we're in the settlement, we get S4 and we get the tilted balance that way. If we're outside the settlement, we get S5 and we get the tilted balance that way. And so you might think, so it's a moot point. Where it's probably going to become more prominent is circumstances where the council do have a 5-year land supply and you want to argue we're still within the settlement. But that, if you've got a clearly defined settlement boundary, I think that would be relatively straightforward to argue. It's where you've got these sort of nebulous settlements that don't have those boundaries or don't have a clear way of determining that. I'm going to jump back. NDAF, hi NDAF. Does the PDL exception section 5 require a sustainable location? No. That's NDAF. That's it says it should be approved unless the benefits of doing so would substantially weigh by adverse effects when assessed against the policies in the framework. And it talks about the redevelopment of pre-developed land. So you would satisfy the tilted balance. Now, you could argue that notwithstanding the fact that you get the benefit of the tilted balance, local authority could say, but you're in the middle of nowhere. There's nowhere for residents of your scheme to go for the local shop or otherwise. And that's an adverse effect, which weighs heavily against your scheme. And that would be a perfectly legitimate point. But to satisfy this requirement, there's no separate sustainability criterion to ultimately get the benefit of the tilted balance. Okay. I imagine this was going to be the area that most people are going to have the most questions. So let me just pick up a few more. David asks, railway station policy trumps Greenbelt. There is a separate policy on Greenbelt and railways specific to Greenbelt. So I'll come back onto that, David, when we come on to Greenbelt. Andy says, in terms of S5J, give weight to the utility providers who are seeking to delay development occupations due to limited infrastructure capacity. I mean, ultimately, I think the question ultimately in that circumstance would be, well, is there availability of infrastructure? If there isn't availability of infrastructure because a utility provider is unwilling to provide it, that might weigh against the scheme. I mean, ultimately, the most inspectors will just need to be satisfied that there will be infrastructure. I mean, if it's a utility provider, one thing that I'm going to go on a complete jump away from this policy, but just look at what's dealt with here. We get a new policy, DM7, which is the relationship with other regulatory regimes. And this is a welcome recognition that the planning system can't solve all problems. And it tells us decision makers assume, unless there's clear evidence to the contrary, that there's separate regimes. A lot of utility companies are covered under separate regulatory regimes. They will operate effectively, and we shouldn't seek to duplicate or extend controls imposed by separate regulatory regimes. So ultimately, a lot of utility companies, there are separate statutory regimes that cater for them. If they're saying, well, notwithstanding that, we're not going to do it, or it's not going to come forward, well, you can push back and say, well, under this new policy, there's an acknowledgement that if there's a separate regime dealing with that, we don't need to deal with that into the planning system. There's a regime already in place to deal with that. And that may well be an argument that arises when you're talking about infrastructure, particularly in the context of utility companies. Sophie, I'll take a few more questions and I'll move on, folks. Sophie said, how would you interpret footnote 26 in terms of frequency and services? Are 4 services required per hour, or could this be a median across the day? I don't imagine there's ever going to be a policy that dictates such a strict requirement. So I'll share the policy that Sophie's talking about. Well-connected railway stations underground and those in which the normal weekday timetable are served or have reasonable possibility being served due to planned upgrades throughout the daytime by 4 trains or trams per hour overall, or 2 trains per hour in any one direction. And your question is, how do we look at that in terms of the frequency? I mean, it's saying 4 an hour. I don't imagine that in terms of median across the day. I mean, I don't imagine they're thinking it's 4 an hour at 2 a.m. So that would have to be some appreciation of 4 an hour at the time, at the reasonable time. So I don't imagine that would necessarily be a median, but just more a recognition that there are times when those sorts of trains wouldn't be running. That's how I imagine that would be approached. But good question. I hadn't thought about that. Okay, I'm going to move on, folks, but I will be coming back to questions. The next point I'm going to talk about, so I'm really going to jump around at the different sections of the NPPF. I'm going to talk about heritage, and I'm going to just be hitting a bunch of different topics now. So, heritage, page 92. I want to take you to. Again, we've got, as you can see, consistent theme, division of plan making and development management policies. Now, I've seen some debate about these heritage policies already, which is why I'm coming to them, because the thought is, well, everyone who's familiar with heritage assets will be familiar with the expression of less than substantial harm. And almost all times where there's an effect on a heritage asset, most of the time we're talking about less than substantial. There aren't that many instances where substantial harm actually arises. But that expression doesn't arise here. What we have now is that we're told where development proposal would harm the significance of a designated heritage asset, the effect on the asset and its significance should be weighed against any public benefits resulting from the proposal. Notice it doesn't say refuse, which is relevant to the earlier section where we talked about the presumption, that where we're talking about unless there are the policies which actually would mandate a refusal in terms of these national decision-making policies. But what we also have is a development proposal would cause substantial harm to. So there's a test for where there is substantial harm to a heritage asset. Well, if there's one test for substantial harm, that obviously envisages that there is a different test, i.e. here, when it's not substantial. You could call it not substantial. You could call it less than substantial. But ultimately, to my mind, it largely preserves that same distinction, which is if it's substantial, you go down this route. And in that context, you can see the word refused does arise. But in the context of it being something less than substantial or not substantial, you then go on to just a weighing exercise. It's very similar to how we deal with that now. So at first blush, it seemed to be a very different approach, but actually perhaps on the detail, it's a matter of form rather than substance. Where some people might get excited about is on non-designated heritage assets. It says that you should only be supported where the harm or loss is outweighed by the benefits of the proposal. Notice it doesn't say refused. And I think that is relevant because when we looked at the presumption in favour of sustainable development, it very clearly uses the language of being refused. Not being supported, to my mind, is different language. Some I've seen suggest that this gives greater protection to non-designated heritage assets, given over how they are now. To my mind, it doesn't. I think it's broadly similar, which is ultimately you weigh it into the balance. Okay. I'm going to move on and talk about the natural environment, but before I do, I'm just going to jump back to some questions. Matthew talks about well-related in policy S5J. Is that just a physical relationship or in terms of urban design or scale? Probably all of the above, to be honest, Matthew. I mean, it calls for a planning judgment as to whether it's well-related. I mean, if it's an outline scheme, which a lot of sort of schemes of this nature probably would be, then I imagine you're not really thinking about urban design scale. You'd be thinking more about just the physical relationship of the site and normally you could judge that from an aerial view on most settlements. It's a sort of a gut instinct, but I imagine you can bring in everything. I mean, if one imagines that you've got to have a huge buffer on your site that creates a divorce between the settlement and development on your side, and you might say, well, then it's not well related because you've got this huge buffer. But so it's site specific. Jonathan asks, if the council's policy already supports housing development adjacent to a settlement, would such a policy now be considered a limited rate if the draft version were adopted in its current form? No, it wouldn't, because going to jump back to that, because if there is an existing development plan policy which supports your proposal, then you would be accorded with an up-to-date development plan. But I suppose if you're outside a settlement boundary, then there'll be an argument. It would depend on the purpose, whether the development policy is allocated for that purpose. If there's just a generally permissive policy, then it is arguable then that you are not in accordance with... I'm going to actually go back on myself because it also talks about, and also the decision-making policy in this framework. The decision-making policy in the framework don't support that type of development adjacent to settlements where there's a 5-year housing land supply. And you can see that what it says is all our development proposals which do not fall within the category set out above should only be approved in exceptional circumstances. So you'd be in the odd circumstance where you'd say, this proposal accords with the development plan, but there's a material consideration that weighs against it, which is the NPPF, which doesn't support development outside the settlement boundaries in this instance, because we don't have a 5-year supply. So therefore, the NPPF says it should only be in exceptional circumstances. I mean, arguably, there's exception where you've got a development plan supporting it in those circumstances. But interesting question. Neil, hi Neil. When balancing the heritage harm versus the benefits as per HE63, this is the tilted balance as per S4 and S5. I don't actually. So let me jump back to HE6. I think the answer to that is probably no, because what you would have here is ultimately it's significant to be weighed against any public benefits resulting in the proposal. It doesn't say should be weighed how that weighting exercise should be done in terms of you should tilt it. So to my mind, that's a flat weighting, which would mean HE6 might be telling you that proposal, the public benefits don't outweigh. But critically, this policy here doesn't say you refuse. So jumping all the way back to that development management policy, whether you're in or outside of a settlement, you can see that we've got a policy which talks about failure to comply with one of the national decision-making policies, which state development proposals should be refused in specific circumstances. And similarly, we've got failure to comply. So that would mean the tilted balance applies. Let's assume that's the case. HE6 weighs against you, but it's not one of those specific circumstances that says you'll be refused. So to my mind, that just goes within the failure to comply with HE6 goes into your tilted balance as a scheme that goes against, and then you've got to decide, well, where's the harm with HE6? Does that substantially outweigh the benefits? So in a roundabout way, you do kind of think about the tilted balance. But I hope that's quite a techie question, which is no surprise from you, Neil, but I hope that makes sense. I'll take 2 more questions, then I'll move on, folks. Pet, hi Pet, says, how will S5 1J play out in circumstances of a plan adopted without a 5-year supply on day one? Well, it would apply in the same circumstances. If the council don't have a 5-year housing land supply through the development plan, then it applies as it would whether it's the end of the 5-year period or the beginning of the 5-year period. And then Kate Grimshaw asks whether the words lawful development in the definition of PDL prevent land over which the passage of time has become lawful from falling within the definition of PDL. A good question, and that actually is not a new question. That is one I had thought about when we got the current iteration of the framework. There's still no answer to it, but my own view is if it's lawful, it's lawful through the passage of time, it's become immune from enforcement, then I think you would be able to say it's pre-use developed land. Okay. While we're talking about, I just mentioned enforcement. There's a very brief point to make about enforcement on this framework, and it's that, unauthorized development. If it is concluded based on the evidence that the unauthorized development was intentional, that fact should be given substantial weight in considering whether to grant permission. So this is if unauthorized development, and you're thinking about a retrospective permission. If it's intentionally a breach of planning control, then you give substantial weight against. Well, this notion of intentional unauthorized development is not a new concept. We've had written ministerial statements about it. We haven't had sort of such a clear mandate and potential weight, but now it's built into a policy. So clearly that's to my mind, quite a big change, because now you've got to explore this question of whether it was intentional. Okay, the next point I'm going to talk about is in respect to the natural environment. This is an area where I think there's been quite a change in terms of the approach to landscape, because For anyone who's familiar with dealing with landscape or the natural environment, we've had a pretty trite position with various iterations of the framework, which is, you've got your nationally designated landscapes, your national landscape or otherwise, or landscapes that are protected within the development plan. Outside of that, which is a lot of sites, you then sort of go down sort of two routes, which is a valued landscape or is it a non-valued landscape? And there were sort of different policy tests in the NPPF dealing with them. The notion of valued landscape is no longer within this NPPF. And there was a lot of guidance from landscape professionals, Glivia 3, and specific guidance on what constitutes a valued landscape. That being gone, that guidance from landscape professionals still exists, but it doesn't have a policy hook. And there's been quite a lot of changes that are being proposed here. I'm not sure what the intention is. I'm not sure how this is going to make a difference in terms of going forward. Certainly, there's an uncertainty that's being created by this. I also note that now, when we're talking about agricultural land, there is a sequential test that is imposed. Though there is a sequential test on BMV at plan-making stages in the current framework. It's not there for decision-making purposes, but this introduces that test for significant development for BMV. Okay, the next point I'm going to move on to, a really quick point, validation. We're going to get some uniform approaches to how local planning authorities want to validate applications, and there's going to be decision-making policies that deals with this, and local validation lists can only go above this where there's a specific development plan policy requiring a specific further assessment. So happily, we're going to start to see some standardized validation requirements across all types of schemes. I'm going to stop then to see how we're doing on questions. John, has paragraph 11 of the 20 carried through, or are there subtle changes? It's not carried through. It's a completely, in terms of the mental gymnastics one has to go through, it's a very different exercise. Whether it results in a lot of the same sort of schemes getting permission and the same sort of schemes being refused, we will see. I don't think it's going to be as seismic of a change in that respect as some people think. For example, there's a lot of schemes I've already been looking at, and we've got to think, well, how would that scheme marry up to this current iteration of the framework? And a lot of the same sort of schemes, you think, well, we're going to go through essentially the same exercise, but you're going to have to write it a different way. And that's not me to say that this NPPF doesn't make a big change, because it does. But on that specific question, at first blush, big change. When you dig into the dig deeper, a lot of times you think, difference in form, not in substance, depending on the facts. No, that was so heavily caveated, but I am a lawyer. Okay, Greenbelt. There isn't actually a huge amount of change in terms of Greenbelt for the purpose of decision making. What we get is the a new policy which supports railway stations. So I think someone asked me earlier about railway stations and Greenbelt. Ultimately, there is a new exception to development of the Greenbelt. So development which is considered appropriate in the Greenbelt where you have a relationship. I'm not going to go through every aspect of it, but where you have a relationship to railways, that there's a new type of exception that's going to be introduced, brand new. We get the grey belt, which is carried over from the current iteration of the framework. It remains largely intact, except for the fact that the definition of grey belt is ever so slightly streamlined. The current version talks about footnote 7 restrictions. That's removed now. It's simply just about whether you add the contribution to the purposes A, B, and D. But by and large, the consideration of grey belt remains very similar. The two big changes on green belt policy in terms of decision making is this railway policy and a consideration of viability, which is that there are going to be limited circumstances where you can bring in viability for these sorts of green belt sites, where there are specific, so multi-phase strategic site, pre-developed land, development, which is wholly different to that assumed in the viability assessment that informed the development plan. So the current currently, when you're going through sort of the golden rules, there hasn't been scope to introduce viability, but this brings in specific circumstances where you might be able to bring in viability when considering these sorts of grey belt sites. Speaking of viability, potential is quite a lot afoot in terms of what's happening with viability. We've got this policy DM5, which says there may be limited circumstances in which it would not be possible for development to proceed on a policy-compliant basis, and you might have a viability assessment. It talks about then whether there's deviations from the assumptions that inform the development plan. So almost like you've got to demonstrate something's changed on the assumptions of the development plan. But then we get this sort of nebulous aspect here, which is all viability assessments reflect the recommended approach in planning practice guidance, utilising the standard inputs set out in Annex A to be added subject to the outcome of this consultation and should be made publicly available. Now, no one is going to be able to intelligently tell you, unless you're in the government, what that means. But seemingly, viability is going to have a new standardised approach, and what that standardised approach is going to look like and how it's going to factor into our viability assessments, I'm certainly not sure, and I doubt many are. But it struck me that there might be a more standardised approach and a more restrictive approach to considering viability. Okay, let me just jump back to see how we're doing with questions. Stuart asks, GB7H, set all requirements. So GB7H, let me just jump back to that. I think your question is, GB7H, do you have to satisfy them all? Yeah, that's certainly my reading of GBH. That you've got to qualify for under H, you've got to meet all of these requirements. Now, the word "and" isn't there, but that's my reading of how this policy would work. And it would be odd if it didn't. In fact, I don't see how the policy could work, because otherwise, if it didn't mean you've got to meet all them, then that means you could only meet one of them, which would mean all you need to do is meet a GB8 if you made your development, which would actually ironically bypass the grey belt. So it would have to be the case that you've got to meet all those Roman numerals in H for that policy to make any sense. Maybe that's a drafting error that the word "and" doesn't appear there, but if it doesn't feature in the final version, I can't see how anyone could interpret it otherwise, because the policy wouldn't make sense. Highways, you'll see that there is a continuation of the standard approach to highways. There's nothing really to see in terms of highway approaches. We've got the same standard test. All development proposals should be capable of proceeding without having a severe adverse impact on the transport network in terms of capacity and congestion, including cumulative impacts or non-acceptable impact on highway safety, taking into account any mitigation measures proposed. So essentially the same test as we have now. I'm going to talk about very briefly plan making. Now, you might think, isn't it odd that we've talked about this new NPPF and we've not spent a huge amount of time talking about plan making? The reason for that is because for the purpose of plan making, in terms of transitional arrangements, we're told that all of the plans prepared should be produced in accordance with the version of the framework published in December 2024, unless any of the transitional arrangements in Annex 1 to the framework apply. Long story short, that current plans that are going through examination or going to be submitted for examination are going to be determined against the current iteration of the framework, not this version of the framework, which just necessarily means it's going to be a while before we're actually going to see how this iteration of the framework is going to actually make a difference to plan making. But notwithstanding that, I'll deal briefly with what we think is going to come with this iteration of the framework, which is sort of a new tiered approach to how plans are going to be produced. Because what we're going to have is these spatial development strategies, and then sort of beneath that, local plans, and then we're going to have minerals and policies maps, and then we're going to have some supplementary plans and neighbourhood plans. Now, when I say beneath, I'm not suggesting one is less important than the other, because they all form part of the statutory development plan. One doesn't necessarily have, one doesn't trump the other in a hierarchical sense. It's more that the spatial development strategy, for example, is intended to go for 20 years, and it's meant to set out what the housing requirement is, looking at objectively assessed need. And then that is intended to inform the local plan housing requirement. Now, there's policies which talk about, for example, under S1, which talks about spatial development strategies, and for local plans where a spatial development strategy is not in place. So spatial development strategies, they are meant to come up with your housing requirement, and it's not for local plans to sort of revisit that unless you don't have a spatial development strategy. We've then got, and again, I'm not going to spend a huge amount of time on plan making because it's, for the moment, it's the less interesting of the changes that are being proposed, to my mind. But what we get is the duty to cooperate. Whilst that is no longer with us, what we will have is still a need to demonstrate cooperation between plan-making authorities. And there's also a whole section about dealing with the examination of each plan. So there's a specific policy on examining spatial development plan strategies, and you can see that we've got usual tests of soundness, albeit the specific language of each test varies, and then local plans, which again we've got still the same positive, appropriate, effective, consistent, but with a more streamlined approach to each of them. To my mind, is that going to make a huge difference? Probably not. I do think the restructuring of how local plans will work, I can well see that making a difference, that we've got these new sort of tiered approach of spatial development plan strategies, local plans or otherwise. But these tests of soundness and the way in which the NPPF is going to approach them, I don't think is going to make a huge amount of difference. And again, neighbourhood plans, just dealing with basic conditions. I should say, in terms of neighbourhood plans as well, if anyone's thinking about the deference that the current iteration of the framework applies to neighbourhood plans, specifically paragraph 14 of the NPPF, that's essentially preserved through policy S6, which tells us that the adverse effects are likely to substantially outweigh the benefits where the plan's part of the development plan for 5 years and it contains allocations. I'm going to talk about housing requirements in a moment. I'm just going to see how we're doing on questions. So, David, unless the nature of development would make this inappropriate in S5J, is not intended to limit the ability to bring new settlements forward. I'm not sure I understand the question. Sorry, David. So, I don't think policy S5 is a policy to facilitate a new settlement. No, I don't think you could use S5J to bring forward a new settlement. I think no, you've got to relate to an existing settlement. Richard, hi Richard, asks, previously the highways with significant impacts should be mitigated where cost effective. This seems to have gone. Therefore, we're just jumping straight to the severe test. No, you can still... to my mind, I don't think that there's been a change in the severe test. Are you suggesting that if it wasn't cost effective to make it not severe, then that gave you a discount? I mean, if that's the approach, I think you're right. That's not what this current version of the framework's envisaging. Ultimately, if it's severe, then you would be refused. Now, you can obviously bring in mitigation to make sure that the impact are not severe, but I don't think it's open to you to argue that, well, it's severe, but it's too expensive to make it not severe. I don't think that's an argument that's open to you. Matthew. So asking about whether HC8 gives greater protection to local green space. Let's get up HC8. So let me share my screen. Yeah. It would certainly, local green space is now akin to greenbelt. So definitely there is a greater amount of protection to local green space. And we saw that. I think somebody else asked the question about that even if you're within a settlement boundary, but you are going to cause harm to a local green space, then that would disapply the presumption, or likely to disapply the presumption in favour of sustainable development. So yes, you're absolutely right. There is greater protection to local green space. I was going to talk very briefly about housing requirements. So if I jump to page 116, and what we have here is the same policy in large part, where for the first 5 years of a local plan, having assessed the housing requirement and development plan, so the first 5 years of a plan, it's whatever whatever the plan has decided is the housing requirement. That's the housing requirement local planning authority have to provide for in meeting their 5-year housing on supply. After that, they then move to the standard method where that plan's more than 5 years old. There's been the change is there was in the current version of the framework, it says after 5 years, it's the standard method unless there's been a review. And those reviews could be an incredibly light touch review. It could be as simple as a local planning authority sending a committee report, taking a report to committee and saying, we looked at the plan, we think it's great, doesn't need to be reviewed. Oh, sorry, that is the review, doesn't need to change. And that could be sufficient to justify the council still relying on the housing requirements and development plan. That opportunity is gone under this version of the framework. Now, after 5 years, it's standard method. And in the interim, let's say year one of your local plan, the housing requirement says the housing figure is, for argument's sake, 100 dwellings per annum. Standard method might be saying it's 300 houses per annum. And we might see that with the versions of the NPPF being examined against versions of local plans being examined against old versions of NPPFs. Even if that was the circumstance, standard method says 350 homes per annum, local plan requirement says 100 homes per annum. You couldn't use that as an argument to try and make an argument about housing need, because what we've got here is that where a local planning authority can demonstrate a 5-year housing on supply, and they've not failed against the housing delivery test, if the most up-to-date local plan housing need figure is greater than the housing requirement set out in the adopted development plan policies, this should not be considered as evidence of unmet need for a period of 5 years from the date of the plan's adoption. So, ultimately, during that 5-year window where the local housing requirement is the housing requirement, it just doesn't matter what the standard method says. This is sort of saying, you just forget about the standard method. It's all about what that housing requirement is. And it's not an evidence of unmet need to not meet it. We still have the housing delivery test. We still have the same approach to judging whether a site is deliverable. The test happily has not changed. So a lot remains the same in terms of how we deal with housing requirements, except for that review point. Okay, let me just jump back to see how some questions have come forward. Apologies, folks, if I have jumped over a question. It's not. Please don't take it personally. It's just my ability to keep up with the questions as they come. So Brittany asks, PM2 should from the minimum period of 15 years for local plans. Do you think this will leave no leeway for local plan authority with less than 5 years in the plan period post-adoption? Interestingly, Brittany, there is something because there's this draft version of the NPPF, and then there is also the consultation wording, and that actually asks the question whether 15 years is an appropriate point, and whether that 10 years is a more appropriate point for local plans. So these, again, going back to that tiered approach, the spatial development strategies, we're told on page 7, they should have a minimum period of at least 20 years. Local plans talk about 15 years, but there is, as I said, there's a suggestion 10 years might be more appropriate in the consultation document. So we'll see. Clearly, there's a thinking how that manifests. We'll see, but there's a thinking that it might end up as being a shorter period for local plans. Andrew Moss asks, S5 criterion 1D allows for the redevelopment freeze developed land. States that the development proposal comprising isolated terms which those lying outside the settlement could not be approved in accordance with policy HO1. Oh, I see what your question is, Andrew. Yeah, you're sort of thinking, is the presumption pulling in different directions? So if we go back to the presumption in favour of sustainable development, so let's say we've got a site. It's previously developed land. It's outside a settlement, and everyone agrees it's previously developed land, and therefore we would get the benefit of the tilted balance under S5 because they should be approved unless the benefits of doing so substantially outweighed by any adverse effect. But you'd be then saying that, well, what happens if it's an isolated home? Even though it's outside the settlement boundary and you get the benefit of the tilted balance, you get the benefit of, you also need to consider it against this policy. I can well see your point, actually. It's not one that occurred to me looking at this, but you might, in those circumstances, say, well, we've got the tilted balance, but we've also got a policy which is directing us to HO11, which is addressing specific circumstances where you should only have isolated towns. Because obviously, and this goes back to, I think, Endas's question, which is, well, I've got a site that's PDL, but it's in the middle of nowhere. So it's still an isolated home. So I think in those circumstances, you might have sort of two policies in the NPPF pulling in different directions. And I imagine the way in which you resolve this, and I'm just saying this off the top of my head, is you'd say tilted balance applies, but in the context of tilted balance, we've got a policy HO11, which tells it doesn't support this sort of scheme, and that would weigh against the proposal within the context of tilted balance. And that just goes into, well, does the fact it's isolated and divorced from any facilities and services or otherwise, does that substantially outweigh the benefits? I think that's the way in which you'd approach that. But really interesting question. I'm going to deal with a few very brief other points, and then I'll come back to questions, folks. Retail. There isn't a suggestion of change in terms of retail policy as things stand, but the consultation version of the NPPF does talk about potentially dropping the requirement for the sequential test. So the sequential test in terms of retail policy is still there, and it's a basis for refusing development. Bear in mind the significance of that word refuse. But what we see, so this is the accompanying document. What we see at page 56. Given Class E's come in, this has reduced the influence of the sequential test for retail development, as it means, for example, that some non-retail premises away from town centres can change to a retail use without requiring permission. There is also an argument that sequential test, where it still applies, creates unnecessary inflexibility where development for main town centres can be located. So, sequential test is still there. Whether it's going to survive, we don't know, because this is obviously someone in government is thinking, should we be getting rid of the sequential test? That's retail policy. In terms of economic policy, and there's loads of points I could be making, folks, but I'm just trying to hit some of the big points. What we've got now is a mechanism to demonstrate whether there's an unmet need in terms of needs for business land and premises. So this unmet need, that directly ties back into, so if you've got a site, this presumption favours sustainable development. So if you've got a site which is outside a settlement boundary, so you're looking at policy S5, you want to say, well, we're going to address an unmet need. So that could be an instance where you are a housing site, but it could be storage distribution, or it could be for a scheme which just is unrelated to housing. And we've got a mechanism here which tells us how you judge whether there is an unmet need. I think this is quite a welcome policy, because anyone who's familiar with arguing these sorts of sites, it sometimes could be quite nebulous trying to argue or trying to identify, is there an actual unmet need for this type of development? And this gives us sort of a policy approach on how you should be approaching that debate. And then almost done on terms of big points, flood risk. There is, in terms of the approach to the sequential test, a lot of the policies that have been sort of coming forward through the PPG in terms of flood risk, which some people would characterize as correcting an over-onerous policy on flood risk. has been brought in to this NPPF. So what we've got is the sequential test and flood risk is still there, but there are circumstances where you don't have to apply it. For example, where you've got a site-specific flood risk development, which demonstrates you don't have any built development within the site boundary, including access or egress, which that reflects paragraph 175 of the current framework. But then we've also got this, which sort of reflects what's been happening with the PPG, which is for surface water and flooding only, it can be made safe for its lifetime. If you can demonstrate that, that discounts the sequential test for policy. Right at the end, and I'll turn to some questions. Interestingly, we've got a new type of affordable housing, military affordable housing. Doesn't require a huge amount of imagination what type of affordable housing schemes we're looking at. And we've also got a new type of size of scheme, which is we've got medium development, which is houses where there's 10 to 49 homes, inclusive will be provided in the size of an area of 2.5 hectares. This NPPF doesn't really tell us an awful lot about what these medium sites are. There's a requirement on plan making to cater for them, 10% of the requirement for these sorts of sites. But I think we're going to see other guidance which deals with this, including whether on these types of sites there is a greater opportunity to provide cash in lieu of actually delivering affordable housing on site. Okay, folks, that's a real canter through. I'm going to turn to some questions now and try and answer some of them as I can. Thanks for those who have stayed on. Stephen has asked, does the change to the glossary's definition of edge centre for retail schemes not change the instance where an impact on sequential test will be required, using a town centre boundary rather than a primary shopping area boundary? I think that's a fair point, Stephen. And the reason why I'm not going to go into any more detail, because I think that retail policy is something that we're really going to have to wait and see what they do. I mean, that text in the consultation document rather speaks to me as that there's a real thought. Are we going to have a sequential test at all? I don't personally advance a view on that, except for the fact I think it's arguable it could go either way, given that they're asking those questions. Mark asks, he agrees with you. Keith, thanks very much. And then any change in terms of limitations of development around major hazard sites? Tim, I'll be honest, I don't know. There might be, but I haven't. If it has, that's probably not been on my radar. But I think, folks, you've probably had to bear with me long enough. So I'm hoping that was a good canter through this NPPF from hopefully a neutral position. Thanks so much for joining me. I hope you got something out of it. And thank you so much. Have a great Christmas and New Year. And hopefully I'll see many of you next year. Okay, well, thank you so much.